Welcome to Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson, and I am the owner of Covert Ops Jury Investigations. What do we do? I'm glad you asked. We search for jurors who lied during jury selection so they would be chosen and our clients would be convicted. In this podcast, I'm going to talk about another client's case, and I'm going to expose all the reasons why he, sadly, is still in prison. After Martin got out of prison, one of the very first cases that we actually started working on was for a family in Okaloosa County, Florida. I spoke at great length with the wife, who was out in the free world, as they call it, about her husband's case. He had been in prison since 1996, so it had been a while. We were able to look on the clerk of court docket and find his jury voir dire transcript. So we got a copy of the jury voir dire transcript and the trial transcript and started looking into the case to see if there was something we could do to identify the jurors, which of course is the very first thing we have to do, is to know who the jurors were who convicted our client so that we can be able to locate them in some sort of online footprint. Remember, we do not contact the jurors ever. We don't contact anyone we're researching. For various reasons, primarily because we don't want them to know they're being investigated for a crime. Remember, it is a third-degree felony to lie to the court, and that's what juror misconduct is, from what I'm told, although, as I say, as a disclaimer, I'm not an attorney. After speaking with the wife a few times, we were able to get the information we needed to be able to take the case, which meant I had the transcripts, I knew who the jurors were who convicted her husband, and we were ready to go. So we started working on the investigation. And we typically start with the foreperson each time, just because the foreperson is the one person in the jury room who has the most influence over the other jurors. And if you've watched a prior podcast, you know that I was a jury foreperson one time. So I realized that you carry great weight when you weigh in as to your opinion. So we started with the foreperson. His name was Stephen Cook. When we started looking on the clerk of court docket for Stephen Cook, we realized that he had quite a few cases in Okaloosa County, criminal cases. We then searched surrounding areas and found that he had other cases in other counties in and around Okaloosa County. All in all, it was quite concerning, all of the things that we were able to find on this jury foreperson. We started working on the investigation. One of the key documents that we use in every investigation is the verdict form. Now, why do we need that? Well, we like it because it has the foreperson signature there, and we're not handwriting experts, but we can look at that and tell if it matches somewhat to a traffic ticket or a property deed in the county. And that helps us to just further identify one of the jurors. And as I've said, in my opinion, it's the key juror because it is the foreperson. So this particular person signed it Stephen D. Cook, Jr. And so now we had his full name as well, and we could look for that in other documents. When we searched online for arrest records after discovering all of the documentation in the Santa Rosa and Okaloosa County Clerk of Court files with criminal cases regarding Mr. Stephen D. Cook, we then searched for the arrest record and mugshot. And there he is. Now, I'm only showing you this because he is deceased. If he were still living, I wouldn't identify him, but you could see why that picture right there was a little concerning. I thought, all right, well, we need to look further into Stephen D. Cook. The other thing that was interesting, too, like I said, we looked to identify pieces of information. This is one of the first appearance documents on the docket, and as you can see, there's his signature, and it closely resembles the verdict form signature. So we were relatively certain that we had, in fact, located the foreperson in our client's case, and that those were his criminal cases on the docket. Another thing that we do is, in every investigation, is we request law enforcement records from every county that the jurors have ever lived, along with their friends and family and everyone else that we're investigating. We did that for Mr. Cook, and we were provided several documentations from local law enforcement agencies regarding DUI and worthless checks and other issues that he had with the local law enforcement. So once we completed the investigation, we realized that Mr. Cook was the primary subject, or was going to be the primary subject of my report. And in fact, that is exactly who I wrote the report on. So this report is dated July 25th, 2019. This is my report of findings for our client. And it talked about that on March 10th and 11th of 1997 is when the jury voir dire was commenced. I want to just read you a few pieces of information that I always put in the reports that I pull from the voir dire transcript, because my intent is to show how often let me back up. How often the jurors are asked to speak the truth, are ordered to speak the truth, to be forthcoming, et cetera, by not only the judge, but typically by the state attorney and sometimes even the defense attorney. The other reason why I quote from the voir dire in my report of findings is because I want everyone who reads it to understand what questions were asked of the jurors and what answers the juror in question gave or failed to give. The judge in this trial was Honorable Tolton, and he said to the prospective jurors, "This part of the case is known as the voir dire examination. Voir dire means to speak the truth." And I will add that I don't believe I've read a voir dire transcript where the judge did not instruct the jurors as to what voir dire means. They might not come out and say that it means to speak the truth, but they will say it means it's important for you to speak the truth, or some variation of that. In this case, Honorable Tolton said, "A voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or some special knowledge which you may have concerning the subject matter to be tried. The full object is to obtain 12 persons who will impartially try the issues in this case upon the evidence presented in this courtroom without being influenced by any other single factor. Please understand that the questioning you're about to undergo is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. In doing that, I can't say the questions will not be personal, because they probably will, as far as you all are concerned in many instances. It is very necessary, of course, that you answer truthfully, as you swore to do, in order that an impartial jury can be obtained." Okay. Then, during the voir dire, the Assistant State Attorney Robert L. Morse said to the jurors, "As the judge told you, this is our opportunity to ask questions of you. I'm going to go ahead and apologize in advance if you feel that any of the questions are too personal or of a prying nature. I'll go ahead and tell you at this time, if there's any question that you don't feel comfortable speaking about in front of a large crowd of people, let us know and we can go to the bench with the judge and you can speak about that matter in private with just the lawyers, the defendant, the court reporter, and the judge, of course. Please let us know if there's anything like that that might make you feel uncomfortable." I'm going to emphasize this next sentence. "The questions we ask, the questions I ask, the questions that Mr. Edmond, who is the defense counsel, asks, are designed to select a fair and impartial jury, trial jury. A jury that will base its verdict solely on the evidence that is heard in this courtroom by that jury and the law which Judge Tolton instructs you. That is all our questions are designed to accomplish." Later, he said this trial is likely to last the rest of this week and possibly a little bit of next week. It could take all week and a little bit of next week. Is there anybody that's going to be that this will be an extreme problem for? Anybody who's got a pressing appointment or a concern? When that question was asked, Foreperson Cook said nothing. That's going to matter in a few minutes. The state attorney also said anyone else who already knows they've got a pressing problem or concern that's going to take away from your attention to the trial of this cause this week and perhaps some of next week? Anyone? Okay. So I'd assume then by your silence Everyone else, although jury service is not always anybody's favorite thing to do, everyone else is available to give us their full and complete attention the rest of this week and next week if necessary. Does everyone agree? Okay. Again, Foreperson Cook did not speak up, but he should have. When we look into whether or not we can accept a case, we not only need the jury voir dire transcript, so we know what questions they were asked and what answers the jurors gave or didn't give during the jury selection. We also look at the trial transcript at the end to see if the jurors were polled, to see exactly who participated in the verdict. If they were not polled or if they weren't named, then we scroll up a few pages to see who did the judge exclude or excuse prior to jury selection. Sometimes it's the alternate or alternates. In this case, there were 4 alternates chosen. So as you see, any one of them could have been substituted for Foreperson Cook during the trial and should have been based on what you're about to find out. So we looked at that. We also, another thing we look at is the juror questionnaire. Did they fill out a juror questionnaire prior to reporting to jury service? Some counties use juror questionnaires. Sometimes the jurors fill them out online. Sometimes they fill them out before jury selection. Sometimes they fill them out at the beginning of jury selection. Sometimes those questionnaires are read into the record during the voir dire. In this particular case, in Okaloosa County, they have a juror questionnaire that was used during this trial, and the assistant state attorney referred to that questionnaire during the jury selection. He said, quote, "The questionnaire asks each of you if you've ever been an accused, complainant, or witness in a criminal case," end quote. Now, other jurors who had answered affirmatively, let me back up and say that we don't have this filled in for the jurors. All I have is a blank copy that I was able to get through the clerk of court. So we don't really know what Foreperson Cook said on his questionnaire to some of these questions. For example, are you under prosecution for any crime or any offense that is a felony? Have you or any member of your immediate family been party to any lawsuit? All these questions, we don't know what he said. The only way that we can intimate what he might have said is by reading the voir dire transcript and seeing what other people said. And throughout this voir dire transcript, only those, it appears, only those that answered in the affirmative were further questioned during the voir dire. Foreperson Cook was not. Therefore, we can, and I don't assume, but we can intimate from there that he did not check the correct answer, or he would have been further questioned throughout the voir dire. And that's the case here. Other jurors that answered yes on the questionnaire were questioned by Assistant State Attorney Elmore. Foreperson Cook was not. He failed to speak up even beyond that. Say he did, and they just didn't ask him. He still had multiple opportunities throughout the voir dire to speak up about being accused and charged and even convicted of multiple criminal offenses, but he never said a word about any of it. Now, it's about to become even more concerning. One of the last questions that the assistant state attorney asked, he said, "You indicated that you or some member of your family has been a party to a civil lawsuit." He was speaking to one of the prospective jurors who was later struck. He said, "What is the nature of that?" Now, other prospective jurors who had answered that question affirmatively, again, on their questionnaires, were further questioned by Assistant State Attorney Elmore, but not Foreperson Cook. So that's an indicator to us that he was not truthful on his questionnaire, and he did not correct his false answer about being involved in a civil lawsuit at any point during the voir dire proceeding. So we dug in. During our investigation, these are some of the highlights of what we found. I'm not going to show you all the exhibits. That's not important. But here's what we discovered about Foreperson Cook, who, again, remember, it appears he was not honest on his questionnaire because he was not further questioned during the voir dire, and he never spoke up during the voir dire about any of this. So a few years before trial, he was charged with DUI in Santa Rosa County. Shortly after that, he was charged with having written a worthless check. The same day, a capias was served and a bond was set for $2,000. Again, these are all before trial. Only a few years before trial. And again, I'm not going to read dates. That just will get confusing. This all, by the way, is a matter of public record. It's on the docket. If you want to know more about it, you can reach out to me privately, and I will be happy to provide our clients' information to you. A few months after that, Foreperson Cook was charged with having written another worthless check. And Again, another worthless check. This was a pattern for Foreperson Cook. On October of 1990, he was placed on 1 year of probation in Santa Rosa County for DUI. He was court-ordered to report to an approved alcohol abuse counseling center for alcohol abuse evaluation and participate in a treatment program prescribed by them. Shortly after that, he failed to report to his probation officer. Shortly after that, another arrest warrant was issued for Foreperson Cook for failing to report to his probation officer and failing to adhere to the court-ordered stipulations mentioned above. The next year, a letter was written from his probation officer to the sheriff with the warrant attached, describing Foreperson Cook and saying that his last known address was in Daleville, Alabama. Foreperson Cook was not taken into custody on the violation of probation until long after our client's trial was concluded, which means while he served on the jury of our client in 1997, there was an active warrant for his arrest on a violation of probation for a DUI offense. He didn't mention that either. After that, he was arrested, another worthless check. He was placed on probation, another worthless check. Shortly after that, his wife filed for divorce and was awarded full custody of their 2 children. Another woman initiated a paternity suit. Again, that was one of the questions that was asked, and he did not answer that honestly. That may seem trivial, but in this particular case, our client was charged and arrested, and the motive for having committed this crime was supposedly because of a paternity dispute. That's what makes Foreperson Cook's failure to disclose that he was in the middle of a paternity suit even more egregious. And I might add that we have documented evidence that our client is innocent, if anybody's interested. Shortly after that, he was arrested again with more worthless checks, 1, 2, 3, 4, 5, 6 different places, continued to be arrested month after month after month. Now, here's where it gets interesting. 6 days before he was chosen for our client's jury, 6 days, he had a plea day scheduled for after the trial. Plea day. On all of these charges, he was about to be convicted, and they had, I guess, worked out a plea. I don't know, but it was called plea day. So he was supposed to show up to the court and enter a plea and be sentenced on these charges for March 25th. Now, remember, he was asked, does anybody have any scheduling conflicts? Didn't say a word. On March 25th, his plea day in the 6 worthless check cases had to be rescheduled for April 8th because our client's trial was still ongoing. What? Let me get this straight. So you have charges pending with the same state attorney's office and the same courthouse that are happening during trial, and you said nothing. But it's worse than that. Not only did Mr. Cook say nothing, Foreperson Cook said nothing. The state attorney's office said nothing about this. 2 days after his plea day was rescheduled, he was elected to be the foreperson. He deliberated with the other 11 jurors and decided our client's guilt, and then delivered the guilty verdict to the court. Do you see a problem here? I know I sure do. I actually reached out to the clerk of court after that, trying to find out who the public defender or prosecutor who negotiated Foreperson Cook's plea deal. I wanted to find out who were these people. I was curious, was it the same state attorney who prosecuted our client? We know it was someone at least in that office, and I might add, Okaloosa County is a tiny county. I don't even know if they had more than a few state attorneys in that office at the time. I asked, they couldn't tell me. But I did reach out, and I asked the clerk of court, one of the clerks of court, the records coordinator. I said, I do not see the names of the public defender or prosecutor who negotiated Mr. Cook's plea deal. Would you have any way of knowing who they were? Now, this was in 2022. Again, the case was in 1997, so it was old. The records coordinator wrote back and said, as that progress docket is the sole remaining official record of the case file, if there's not a name listed, then there is not a way to retrieve that information. The docket is what remains of information about that case. So we don't know. We don't know if the person negotiating Foreperson Cook's plea deal was the same person who was prosecuting our client. Am I alleging prosecutorial misconduct? Yes, I am. Can I prove it? No, I can't. Yet. Stay tuned. So we present our findings to the client, who gives my report and the exhibits to their attorney, who writes and files a motion based on this newly discovered evidence. The state attorney is given the opportunity to reply. So I might add that they did. This was actually signed by Lisa Rivers, was the assistant state attorney in July of 2022, who responded to the client's motion for a new trial based on the juror misconduct. So the state attorney's office was given a chance by the court to respond to our client's attorney's motion based on the juror misconduct. And she did. Assistant State Attorney Lisa Rivers responded in July of 2022, citing case law, and then in the final analysis, our client was required with due diligence to prove that Stephen Cook, an unqualified juror. Why was he unqualified? Because he had charges pending. He was unqualified to serve. That was the first, very most important thing, really, was that he was unqualified. First off, he couldn't have even served legally on that jury. Forget all the other stuff. At the heart of this, he wasn't even qualified to serve, and then he became the foreperson. Now, who knew he wasn't qualified? Did the state attorney's office know that he wasn't qualified? Did they already know about everything that we already found? Again, I can't prove that. Yet. We had to prove that Stephen Cook, an unqualified juror, was actually biased against our client and thus denied him of his right to an impartial jury. Our client, she says, did not with or without due diligence present any evidence that Stephen Cook denied him of his right to an impartial jury. Accordingly, the courts must deny our client's post-conviction motion for relief. And it's followed by 80 pages of gobbledygook, case law after case law after case law that, again, not an attorney, but there are very few case laws that determine juror misconduct and control juror misconduct, and you don't need 80 pages to do that. But she filed an 85-page brief, double-spaced. It wasn't long after that we were granted a hearing. Now, this was the first time that I had ever been in court to testify for any of our clients. Shortly after the assistant state attorney, Lisa Rivers, filed all of those 85 pages, the judge actually gave us an evidentiary hearing, and I was called to testify. I'd never done that before. It was quite a learning experience. It was quite a negative learning experience, but it was a learning experience nonetheless. I'd never been yelled at by a judge before. But one little tidbit, so you know, if you go into court and you're sitting in the witness box, don't turn and look at the judge. Don't talk to the judge. And even if you think the judge is asking you a question, don't answer the judge. Because what you're supposed to do is let the judge talk to the attorney, and then the attorney talks to you, and then you tell the attorney the answer, and then the attorney tells the judge. I find, as I guess I'm the theme among these podcasts, is I have lost a lot of respect for our system. It's full of convoluted terms that nobody can pronounce or figure out what they mean. The words are confusing. The names of proceedings, when you get denied, it's a per curiam affirmed, PCA. What is that? Well, it means they affirmed the lower court, which means that you're denied. It's very confusing. Well, that day was very confusing to me, but I learned a lot through it. Ultimately, the judge denied the motion based on our juror misconduct. And here's what he said as to why he denied it. The court finds that the defendant's claim is procedurally barred as untimely because he has not demonstrated that he could not have raised the claim on direct appeal. Defendant also did not present any evidence that the jury foreman's criminal and civil cases were not public record at the time of the trial and direct appeal in this case. The court further finds that the defendant has not demonstrated that the jury foreman's failure to disclose his criminal history, domestic relations cases, and pending criminal charges resulted in prejudice. Defendant has not established that he was denied his constitutional right to an impartial jury by proving actual juror bias against him. Finally, defendant did not present any evidence related to the jury foreman's motives for failing to disclose that information during voir dire. Now, for those of you, again, who don't know what the system means when it says direct appeal, when you go to trial and you lose, the very first thing, especially in Florida, in this case, it's called different things in different cases, or different states. In Florida, it's called a direct appeal. So this judge is saying that our client could have raised this information about the foreperson in the very first appeal that took place right after trial. Sometimes it's weeks after trial, sometimes it's months after trial, but that is the very first appeal. You might hear people say, oh, it'll get overturned on appeal. I heard that a lot in our case. Well, it didn't. And I'm not going to act like an attorney and tell you some things I know about direct appeals, because that could appear to be dispensing legal advice, and I'm not an attorney and I can't do that. And I'm not getting in trouble for that. So he's saying it could have been raised on direct appeal, which means within days of the conviction, our client could have figured all this out in time to raise it in that first direct appeal or argue it in the first appeal. My purview in that is that would have been impossible, and I'll explain. So the judge also said the defendant did not present any evidence that the jury foreperson's criminal and civil cases were not public record at the time of the trial and direct appeal in this case. That is true. They were in the clerk of court's office, and anyone could have gone over there and asked the clerk of court, because they weren't online in 1997, could have asked the clerk of court, hey, did any of these jurors have any criminal or civil cases here in our county? I'm not sure why you would do that, because again, the jurors took an oath. They swore to tell the truth and seemed to tell the truth. So why would you do that? Why would you just assume, oh, I got convicted, so even though I'm in jail and have no access to the clerk of court files, what am I supposed to break out, escape, go to the clerk of court and say, hey, did any of my jurors have any civil cases? I don't know. It just seems like an impossible standard. Then the judge also said the court further finds did not demonstrate that the foreman's failure to disclose all of this resulted in prejudice. What? Well, then how is it that everybody I tell this case to, and all the things that we found, their jaws drop, they're horrified. This juror was not only not legally qualified to be a juror on any case, but he had a plea day scheduled. Was he currying favor with the state by sitting on this jury and ensuring a guilty verdict? It certainly looks that way. In fact, I know from the family members who overheard this foreperson say to the defense attorney after trial, he walked up to the defense attorney and said to him, I'm going to paraphrase, I'm sorry because I know that the verdict did not go the way you had hoped. Why would Mr. Cook have approached the defense attorney if he didn't have some sort of an agenda in all of this and feel bad about it? I don't know. We can't ask him. He's passed on. But this is where I'm just horrified. How can you look at all of this and not feel that this person denied our client his constitutional right to a fair trial by an impartial jury? Was this juror biased? Duh. If he wasn't actually biased, which is how the law is quoted, if he was not actually biased, why didn't he just tell the truth? Why didn't he at some point say, well, as a matter of fact, I am not qualified to be here, or I can't be here for the next 2 weeks because I've got something scheduled in this courthouse and I got to be there. I can't miss that appointment. Why didn't he? He didn't even have to disclose all of his criminal charges or his civil issues, baby daddy stuff. Didn't have to disclose any of that. He could have just said, I'm not qualified. And they would have excused him. He didn't, which leads me to believe he had an agenda. He obviously was biased, but yet this court says no. So that was denied. Now, this is happening in almost all of our cases. The state is arguing that this evidence could have been found sooner with due diligence, and the courts are using that to deny our motions for a new trial. Our clients, like this one, are still in prison. Nearly 30 years of this man's life stolen from him, even though he has evidence to prove that at the time these people were being murdered, he wasn't even in the county. Was that presented at trial? What do you think? I'm going to go back over some of this to try to tie all this together. I think this will make even more sense because, again, the point I'm making here is that the courts are denying motions for new trials based on an impossible standard. You can't meet that standard, and here's why. Our client's verdict came in on March 27th, 1997. At some point after that, his attorney would have driven home. His home was over 400 miles away. Now, our client's sentencing was set for May 21st. It had to be postponed because his attorney became ill. So on June 30th of 1997, our client was sentenced to life in prison and was in the Department of Corrections custody the very next day. So July 1st, 1997, our client was in prison with the Florida Department of Corrections. At that point in time, his attorney was no longer his attorney because he had already filed a motion to withdraw. So at the time that these courts, the state attorneys and the judges are saying that our client could have and should have investigated the jury, uncovered all of this evidence against Foreperson Cook, which took us weeks, but he could have and he should have done that. How? That is the one question they can't and don't answer. How could somebody who's in prison or just incarcerated, they're in jail, they're in prison, they're incarcerated, how are they supposed to even know to investigate the jury? Remember, I did that after watching a movie. I watched a movie, and that's what gave me the idea. Did our defense attorney say that to Martin? Oh, we just lost. Now it's time for you to investigate the jury? No. In fact, I was told by private investigators not to do that because it could be considered jury tampering. Well, I wasn't going to talk to them. I just wanted to see who were these people that came into our trial, heard 3 hours of nonsense, and voted guilty. Well, we know that. If you've watched the prior episode all about Rose, you know how it happened. Back to our client's case. This is what hacks me off, as you can tell. They are setting a standard, setting a bar so high, it is impossible for anyone to meet it, but they're using that standard to deny all of our motions for new trials. So here's our client. He's in prison. He has no attorney. And it gets even better. How's he supposed to know who the jurors were? Because the voir dire was not transcribed until he had already been in prison for 4 months. You go to trial, you're convicted, sentenced. Once you're sentenced, the court orders the transcripts of the trial to be transcribed. You're already on your way to prison, or you're in prison, before the court reporter even gets the order to transcribe the trial. So you don't even have a trial transcript. You don't know who these people were. You don't know what they said. And without that, we don't take a case. If we can't prove what they said or didn't say during voir dire, we don't take the case. So how is it that a client in prison without a transcript, without any knowledge of who these jurors were, or any knowledge that he's supposed to know who they were and investigate them, how's he supposed to do that? Again, it's an impossibility as far as I'm concerned. One thing that was very encouraging about this case is it's only happened in one other case out of all the ones we've worked on. is that our client was granted an oral argument in front of the appellate court. So I actually downloaded this. This was the screenshot of the 3 appellate judges. I'm not going to name them. That's not important. But the 3 appellate judges who were there, I actually watched it live. Our client's family had flown in. They were sitting behind the defense attorney that they had hired, that had written the motion and was now going to argue in front of these appellate judges. And one thing that just jumped out at me, I'm watching it live and I'm thinking, this is awesome. Our client's going home. He's going home. Because at the very beginning, 1 minute and 30 seconds in, this is Judge Roberts. Judge Roberts says, and I quote, I won't say the name of the attorney. Mr. Attorney, it seems reasonably sure that there was misconduct on behalf of this juror, correct? The record establishes that it's pretty clear there was juror misconduct, okay? But I think your first hurdle is going to be whether you're procedurally barred, because the defense may not have been able to discover this record maybe before the trial, but certainly right after trial. And there are some 24 years later. Why are you not procedurally barred? Why was this not discoverable sometime in and around, 2000-ish? The attorney tried to answer it. I thought he did a decent job of answering this ridiculous question, but at that point, the judges just continued to have more questions. Now, again, the state attorney got the chance to weigh in, and she stood up and gave the same argument that the other state attorney had. Could have been found sooner with due diligence. Again, how? No one's addressed that. Here we are, let's see, when did we start this? 2015? So 10 years later, not a single court has addressed that question. How is it you have misconduct? That equals new trial. Misconduct. He said it twice. He already agreed. They already said you have misconduct. Our client should have been granted a new trial on the spot, but it was denied. Why? Well, we don't even know. Why? Because, back to the pure curum affirmed thing, when you get one of these from the appellate court, guess what? It doesn't tell you why you're denied. It just says pure curum affirmed, meaning we agree with the lower court. No explanation, no reason why, just denied. But you already said there was juror misconduct. You already said that twice. That was July 12th, 2023. Our client is still in prison. When you have evidence to prove you're not the guy, and then this happens at your trial, and you can prove that your foreperson was not only not qualified to even serve on the jury, but was definitely, in my opinion, and in the opinion of everyone involved in this case other than the state, he was there currying favor with the state. How do you explain that none of the issues that he was going through, how do you explain a plea day that had to be postponed because he was still sitting on the jury? Somebody in the state attorney's office had to be aware of that, because they're the ones that worked with the public defender's office to postpone the plea day after our client's trial. Why wasn't that brought to the attention of the state attorney who was trying the case? Or was it? 30 years later, almost 30 years later, his family has been without him for almost 30 years. This was a military man. This was somebody who didn't have a criminal record, should never have been accused of this crime, has proof that he wasn't in town. If Mr. Cook were alive today, I would say, I don't know what your motives were, but it certainly looks like you had an agenda. And it looks like you were trying to curry favor so that you could get a better deal for yourself. Meanwhile, this man was sentenced to life in prison with no chance of parole. Now it's been over 30 years. His family has suffered on levels I can't even begin to imagine. If my dad had died that day, it would have been horrific, and it would have been something that I never would have gotten over. But it would have been a mistake. This was no mistake. This was intentional. This was on purpose. This was sinister. And it shouldn't have happened. And our client should not only have never been convicted, but he should not still be in prison. His family has suffered. His wife has been through cancer treatments and surgery alone. He should have been there with her in her hospital room to help her through that. His parents are aging. Family members have died. He's missed everything because you wanted a better deal and the state attorney's office won't own up to it. You know what? You didn't even have to admit you did anything wrong. Just stop with the 85 pages of nonsense and say, let's talk about a deal. Let's work this out. Just like in our case. They held our freedom for ransom, but we didn't care because we went home. That night I was sitting around the pool eating pizza with Martin. I didn't care. Offer me anything. I'll take it. Well, I assure you, our client and his family would have taken any offer that they had put on the table, but they wouldn't even put one on the table. And then they went further than that, but denied him based on an impossible standard this he couldn't have possibly even met. This is what's going on in courtrooms every single day. Every day. It's not okay. It's got to stop. That's why I'm here. That's why I'm doing this, and it will continue. I thank you for watching. I do. I really do. I hope that you will tune in for another episode next week of Jurors in Disguise. Until then, if you know someone that's been convicted and they need our help, reach out. Our contact information is in the description below. Remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.